Welcome, everyone, to the Rogue Thoughts podcast. And today's episode is about the rules that are supposed to keep the world from going completely lawless, international law. And we're putting it under a microscope in three places where it's being stress tested the hardest right now: Russia, Ukraine, and their peace deal in question, Israel and Palestine, and what's lawful versus criminal, and lastly, Venezuela and illegal limits on cross border force. My guest today is Professor Alan Weiner and from Stanford Law. He's a senior lecturer at Stanford Law, and he leads their program in international and comparative law. He also co-directs the Stanford Law Center of International Conflict and Negotiation, meaning he's not just studying war, he's studying how wars end and what it takes to get from violence to actual agreements. Before Stanford, he worked in the U.S. government as an attorney, for the State Department as a legal advisor, and later served as legal counsel for the U.S. Embassy in the Netherlands, which puts him in the heart of international conflict courts and tribunals. Welcome, Professor, to Rogue Thoughts.
Pleasure to be with you. Thanks for having me.
Thank you for being with us. Professor, to my understanding, there are two big core principles of international law, and that's just ad bellum and just in bello. Would you mind speaking about those, what the purpose is,
Sure.
how they are implemented, things like that? And of course, if you feel I missed any core principle, please
You
feel
bet.
free to add.
Well, let's see how it goes. So, you're right. When it comes to the law governing the use of force, and this is an ancient, kind of body of international law, there are these two separate bodies of law: use ad bellum, or the law of the war. Basically, are the rules that regulate when states are allowed to use force in international relations. And we can talk a little bit more about the details of that. Then the use in bello is once a war has started, use in bello is the law in the war or the law of the war. What are the rules that regulate the conduct of warfare? So if we agree on a set of rules, use ad bellum rules that regulate when states go to war, the understanding that international law has adopted for centuries now is that even if one state violates the law governing the recourse to force, the use ad bellum, both parties are still obligated to comply with the rules governing the conduct of war, the use in bello. And the use in bello rules basically are focused on the humane treatment of non-combatants, not mistreating POWs and civilians. I mean, that's the basic gist of use in bello is humane treatment of people who are not participants in war.
And who is supposed to enforce these laws and principles?
Well, you've come to the advanced part of the curriculum already, Greg. Let me first say a word about what the use ad bellum rules are, and then we can talk about enforcement. So let's go back to that use ad bellum and the laws that govern the conduct of war. For most of the modern era, the post-Westphalian era, if you will, states were pretty much free to use force in their international relations in a very discretionary manner. Force was considered to be a means of resolving disputes. So if I had a conflict with another country and we were not able to resolve it diplomatically, then I would be entitled to use force to pursue my rights or my interests. There were procedural requirements. I had to declare war, right? This is where the tradition of the formal declaration of war comes from. You'd usually include in the declaration of war a long rehearsal of the reasons why you're going to war. If you think about our own Declaration of Independence, right, with the long list of things that the king has done that we object to, he's plundered our shores, he's taxed us, etc. That was like a declaration of war. It was the statement of the casus belli, the reason for the war. But in the words of the old Prussian political theorist von Clausewitz, war really was the continuation of politics by other means. Now, the result of that, as we might not be surprised, is that there was a lot of interstate violence in the system. 18th century, 19th century, and especially in the first half of the 20th century, war was an everyday feature of international relations. And as we got to the 20th century, war had become much more devastating. Beginning in the early 20th century, there were efforts to kind of restrict the ability of states to use war. the League of Nations Charter was designed to restrict that. There was a treaty called the Kellogg-Briand Pact. These were largely ineffective, but at the end of World War II, we created the UN Charter, and that has the core use ad bellum rules that apply today. And they are simply, under Article 2.4 of the UN Charter, states are prohibited from using force in international relations. There are two exceptions. States can use force in self-defense if they suffer an armed attack. Some people think that maybe states can use force if they face the threat of an imminent armed attack. And then if the Security Council of the United Nations authorizes force. So that's the basic use ad bellum framework.
So with that said, in your opinion, has the UN carried out these laws and implemented these laws effectively?
So, the UN system for decision making in the Security Council, which is the part of the UN that is authorized to deal with threats to international peace and security, I think it has not worked the way that we had imagined it would. That's because of the voting procedure in the Security Council. The Security Council is made up of 15 states, 5 permanent members of the Security Council: Russia, the United States, France, the UK, and China. And then there are 10 members who serve on a rotating basis representing different parts of the world on 2-year terms. Now, the permanent members, for a resolution to pass in the Security Council, which could include an authorization to use force to deal with some threat to international peace and security, that requires 9 affirmative votes of the 15 members of the Council, including the 5 affirmative votes of the permanent members. So if 14 states vote in favor of a resolution, but one of the permanent members votes against it, the resolution fails. This is what is known as the veto. There's not actually a veto. There's not a stamp where you get a veto and reject the resolution, but a negative vote by a permanent member of the Council blocks the Council from acting. And very shortly after, the UN Charter was created at a time when the permanent members were essentially all allies. These were the countries that had defeated the Axis powers during World War II, Germany and Japan. But very quickly, these states that had been allies started to become rivals. And the Cold War breaks out. The US and the Soviet Union lead blocs that are fundamentally in opposition to one another. And so as a result of that, the Security Council has largely been gridlocked. There was a period of time in the post-Cold War era, starting maybe in 1990, for about maybe for 15 years, when there was a lot more collaboration in the Security Council. But we've seen a renewal of the great power rivalry between the US on the one hand and China and Russia on the other. So it's very difficult to get things done in the Council. Now, that's the bad news. The good news is that the basic rule, which prohibited the use of force by states in the international system, actually has been pretty effective. If you look at the data, the level of interstate wars, the level of interstate violence in the, say, 75 years after the adoption of the UN Charter has been much, much lower than the level of interstate violence that characterized the international system in the centuries beforehand. So states have complied with the rules, largely, not perfectly. Now, I will say in the last 10 years or so, we see an uptick in the level of violence. You talked about the rules that create stability in the international system. Those are under strain right now, in part because of the behavior of the powerful countries in the system, which are disregarding the rules. But the international system in the 75 years after World War II saw much less interstate violence. You asked the question about how are these rules enforced? So I'll come back to that. The truth is, there's no international police force. The international legal system functions quite differently from at least a well-functioning, well-ordered domestic law system. There's no compulsory third-party dispute resolution. If you and I have a dispute about whether or not, you gave me a good recording of this podcast and I think you breached a legal duty, I can bring you to court and you have to show up and defend. If the U.S. has a dispute with Venezuela about whether we legally or illegally invaded Venezuela, there's no court that has compulsory jurisdiction. Now, there are many cases in which states do accept the jurisdiction of a court. There are many international courts and tribunals which are very busy, but you can't be sure that all states will be subject to third-party dispute resolution with respect to all potential legal claims. And most importantly, there's no enforcement system. There's no international police force. How is the law enforced? It's largely enforced through self-help. States trying to enforce their own legal rights through what is known as horizontal enforcement. So think about the response in that regard to Russia's invasion of Ukraine, the full-scale invasion of Ukraine in 2022. Russia's been subjected to very, very significant international sanctions. It's been isolated from international organizations, right? So these are its property, its assets in central banks have been blocked, have been frozen. So these are measures in which that states have taken to try to enforce their rights horizontally in this self-help fashion. But as the Russia case demonstrates, if a state is sufficiently powerful and sufficiently motivated, enforcement of international law is always a challenge, right? And that's why it's important for powerful states to comply with the law.
Since we're on the topic of Russia and Ukraine, you mentioned a full-scale invasion in 2022. And then you mentioned, I think it was UN 24, the Article 24 is the one that
UN Article 24, yeah.
24, that defines force, if I'm not mistaken. Is that what you said?
It prohibits the use of force.
So with that said, is Russia's 2022 invasion an illegal invasion of Ukraine?
Yes. I mean, the short answer is yes. There's no question that that Russia has engaged in an unlawful use of force against Ukraine. Russia's offered a number of theories or explanations or defenses or justifications, but at least in this lawyer's view, I think those are impermissible or unpersuasive justifications. Russia has said that it needed to invade Ukraine to protect ethnic Russians, Russian speakers in eastern Ukraine, from atrocities and genocide that were being perpetrated against those people by the Ukrainian government. There are two problems with that. Number one, there are some people who argue that there is a right to use force. I said the only two circumstances in which states can use force is if the Security Council authorizes it, or if a state is engaging in self-defense after it has been attacked. There are some people who argue that there's a right to use force to basically stop another country from slaughtering its own population. Now, I think most lawyers and almost all states in the system would say that's actually not a recognized legal basis for using force. But the bigger problem was there was no mass atrocities being carried out against ethnic Russians in eastern Ukraine. It simply wasn't true. Even if you could use force to stop a country from slaughtering its own people, the Ukrainians weren't doing that. The Russians have also said that they were using self-defense because they were concerned that Ukraine might join NATO at some point, and that there could even be nuclear weapons stationed on Ukrainian territory. But again, the exception to the prohibition on self-defense applies when a state has suffered an armed attack. Or maybe some people argue that the law has been interpreted to allow a state to use force if it's facing the imminent threat of an armed attack. The idea that Ukraine might at one point join NATO and could conceivably at some point have nuclear weapons on its territory certainly does not meet this test of an imminent threat of attack. And then the trickiest issue is the Russians recognized, as you may recall, two of the territories in Ukraine that declared independence, the Donetsk and the Luhansk People's Republics. And it is now said that those countries have decided to be annexed by Russia. But immediately after they declared independence, Russia recognized those countries as independent countries and then said that those countries had invited Russia to assist them in defending themselves against Ukrainian attacks. The problem there is that these countries did not meet the requirements for being states under international law. And it is true a state can ask another state to assist it in defending itself. Iraq asked the United States to assist it in fighting off the Islamic State. But because the Luhansk People's Republic and the Donetsk People's Republic don't meet the requirements for statehood, they did not have legal ability to invite Russia to defend them against Ukraine. So yes, those are the theories that Russia has advanced. I find them to be unpersuasive, and so I believe that this was a quite clear case of unlawful use of force by Russia against Ukraine.
So I've read that allegedly NATO troops were on the border of Ukraine and Russia. If that were true, would that increase their, I guess, success in their self-defense argument of a imminent attack?
Yeah, I mean, I've not heard that there were. That there were NATO troops. I mean, I have not heard that there were NATO troops in Ukraine. I mean, there are obviously NATO troops in NATO countries, the frontline Baltic states. But every country has an army, or well, except for Costa Rica, maybe, right? And the fact that we have troops in our countries does not necessarily meet the requirement of there being an imminent threat of attack. Canada has troops, and I don't think we could claim, well, we have to invade Canada because they have an army and they might attack us. And so the question is, was there anything that would have given Russia a credible basis for believing that NATO troops had plans to attack Russia? And I think even to state that proposition, is to recognize how absurd it is. It might be that there were troops, in the Baltics, in Poland, aimed at kind of protecting those countries against a possible further attack by Russia. But having troops in a defensive posture is not the same thing as having troops in a position, to threaten another state. Now, the question you ask, when does our behavior cause another state to believe that it's facing an imminent threat of attack? That can be tricky, right? That's why some international lawyers don't really like the suggestion that international law allows the use of force in response to an imminent threat, because they think that creates dangers of mistake, that creates dangers of abuse. Whether or not you've sustained an armed attack is pretty clear, right? That's not something that people can disagree about. Yeah, the bombs fell on my territory, so now I have a right. We were attacked in Pearl Harbor, on December 7th. Okay, so now we have a right of self-defense against the Japanese. But again, I think if we're engaging in a good faith, evaluation, the idea that even if there were troops on Ukrainian territory involved in training Ukrainian military forces, the idea that there was a threat that Ukraine was going to attack Russia, I mean, this is kind of a far-fetched and nonsensical threat.
So currently they're in the peace deal negotiation. I believe it's been stalled for the last day or two. I read that including in the deal, Russia is refusing to give up the lands they've taken currently. And I've also looked at how that since post-World War II, if I'm not mistaken, there have been no deals in which land succession has been part of a peace treaty. I just wanted to get your thoughts on that. And is that true? And if so, how does that apply in this current situation?
Yeah, I mean, look, I think there are some questions about China and Tibet, whether there was, but in general, Greg, you're right. This is part of the success of the UN charter system, after World War II, is that even when states do go to war with one another, and they do, we have not seen the acquisition of territory by force. And when it's been tried, I mean, the other prominent case Iraq invaded Kuwait in 1990 and basically wanted to conquer Kuwait and make it the 19th province of Iraq. And that was something very unusual in that you had this overt, explicit effort to change borders through the use of force. And it was the American president then, George H.W. Bush at the time, who said, this shall not stand. We can't allow this. The international system can't allow states to acquire territory by force. So that is part of what is so shocking and so potentially destabilizing to the international order. Now, I think, I haven't been privy, neither Jared Kushner nor Steve Witkoff are inviting me to the meetings.
Maybe they should.
Yeah, I'd love to go. I'd love to go. If they're listening, guys, give me a chance. My understanding from what I read in the press is that on the territorial issue, both sides seem to agree that there won't be an actual formal peace agreement in which we recognize a change in the boundaries of Ukraine. In other words, there would just be sort of a de facto recognition that the Russians are in control in this area, but we wouldn't legally recognize those areas as part of Russia. It would be, a little bit like deciding what the boundary is between North Korea and South Korea. Well, we don't know, but the war ended here. The Korean War ended here in the 1950s, and this is the line that the troops were at. This is the armistice line, and we're just going to treat that as a de facto line without necessarily concluding a legal agreement of a change in boundaries. And so I'm sure the Ukrainians are hoping that even if they have to cede, even if they have to acknowledge that the Russians will have de facto control over these regions in the Donetsk, in the Donbass, in eastern Ukraine, I'm sure that the Ukrainians are thinking that a day will come when this will be undone and this will be reversed. And this is not a preposterous idea. I served, as you mentioned, as a lawyer in the State Department. The United States never recognized, as a legal matter, the annexation of the Baltic states by the Soviet Union. The Baltic states, Lithuania, Latvia, and Estonia, were annexed by the Soviet Union after World War II. And the United States said, no, you acquired those territories by force. We don't recognize that. Now, in fact, the Soviets were in control, right, in Lithuania, in Latvia, in Estonia. But this long-running belief that those countries were not really part of the Soviet Union lingered. And when the Soviet Union collapsed in 1990, the independence of the Balts was restored. And so I'm sure that this is the model, or I imagine that this is the model that the Ukrainians have in mind, is look, we'll agree for right now that the Russians control this territory. We don't agree that these territories are actually legally part of Russia. And we hope that there's a day in the future, which is presumably a day after Vladimir Putin is no longer the leader of Russia, that the status of those territories can be reconsidered.
That was a lot. I just have a question on that. Wouldn't that kind of make the peace deal, I guess, for lack of a better term, tainted in a way? Almost we're accepting that this is not something that is done, but we're going to allow it to be done until we see an issue with it later. But we don't know when later is.
I share your view. I have been, the original position of the Biden administration was that no change in Ukraine's borders by force could be permitted, and that was the view of our European allies. So I think this administration, the Trump administration, has been much more sympathetic to kind of Russia's demands. They tend to be, the president in particular tends to think, as we all have read, in transactional terms, right? He told, famously, in what struck me as kind of an embarrassing diplomatic moment at the White House, he scolded Ukrainian President Zelensky by saying, "You don't have the cards," right? And that, basically suggests that countries that are willing to grab the cards by force, will be rewarded. And so I think, any recognition of Russian, certainly recognition of Russia's annexation, legal recognition of Russia's ownership of these territories would be the first time that's happened since the UN Charter was adopted. Even this acceptance of a de facto regime with the Russians practically in control, I think, is a reward for aggression. And I think that's why, up until the Trump administration came into power a year ago, Western NATO countries had deeply opposed this.
Just lastly on Ukraine and Russia, do you see this as a bad future precedent for other countries? Let's say hypothetically, like China wants to do the same thing with Taiwan. Is this creating a domino effect of I'm stronger than you and I can take you and I will?
I think the answer is there's very much a risk of that. The question is not so much what did Russia do? We know they violated the law. The question is, do they get away with it? Are they rewarded for doing that? So again, Saddam Hussein invaded Kuwait in 1990, and this was a clear example of a country violating the rules, engaging in aggression to augment its territory and resources. But that was reversed, right, as a result of the first Gulf War. The U.S. led, military campaign to drive Iraqi forces out. So I think if Russia gains much, all, or even much of what it hopes to acquire through its illegal use of force, through its aggression in Ukraine, I think that is a signal to the rest of the world that maybe we're not going to stand by these rules. Maybe violations of international law will be tolerated in a way that they really weren't so much for the past 75 years or so. Greg, you asked at the beginning, how is international law enforced? And, one of my colleagues in the international law scholar community, Harold Coe, who was the dean at Yale Law School, also later the legal advisor of the U.S. State Department, said in a way that I think is very insightful that international law is almost never enforced, but almost always obeyed. And the reason why international law is obeyed is, unlike the laws that maybe you and I are bound by here in the United States, they put a stop sign in at an intersection near my house recently that I find really annoying, because a stretch of road, I used to be able to fly about 1.5 miles, from the big road to my house with no stop signs along the way. Now they put the stop sign in there. I think it's really dumb, right? Now, if I had said, I don't want a stop sign to be there, if I say that to the cop when he pulls me over for running the stop sign, he's going to say, "That's very interesting, sir, but I'm still giving you a ticket for running the stop sign." Right? You're bound by the law whether or not you agree with it. International law is different. International law basically is a system of voluntary agreements that states have entered into, because there is no police force. So states are basically bound only by those rules that they accept. Why do they accept those rules? Why do I accept certain restrictions on my sovereignty, on my discretion to act? Why would I accept a restriction on my ability to invade my neighbors? Well, because I realize, if everybody else also accepts a restriction on their ability to invade their neighbors, that produces a world that is a more stable and a more peaceful world. Now, if states decide that they don't want to obey these rules anymore, then other states look around and think like, well, wait a minute, I'm not getting the benefit of these reciprocal surrenders of sovereignty. My willingness to impose self-limits was predicated on the idea that other states would do the same thing. If you're not going to comply, why should I comply? And so I think, yeah, this is the deep concern I have about Russia-Ukraine. It's the deep concern I have about the United States' use of force in Venezuela, right? Reflecting the idea that states no longer believe that they need to comply with these commitments that they have freely entered into. The United States was one of the leading architects of this regime that said states shouldn't use force against one another, right? If we now say it's okay to do so, then yeah, I worry that we'll move back to the kind of regime that we had before the charter was adopted, when states were using force against each other all the time. And we're back in that Clausewitzian world where force was the continuation of politics by other means.
Just with that said, if we could transition to Israel and Palestine, from what I've understood, one of the biggest questions between the conflict is the self-defense question, and how much self-defense is too much and to what limit. If you had to give an analysis of it, do you think Israel has overused their self-defense argument, used it just right, or is there room for them to expand on that?
Yeah, it's a really good question. So the Israel case is a little complicated because unlike Russia, Ukraine, or say unlike the US and Venezuela, we're not necessarily dealing with a conflict between two states. Even if we accept that Palestine is a state, and that's contested, although Palestine is recognized as an observer state in the United Nations, even if we accept that Palestine is a state, Hamas is not the government of that state, right? So here we have a conflict between a state on the one hand and a non-state armed group. Now that's not so unusual. Think about 9/11. The United States was attacked by a non-state armed group, Al-Qaeda, and we claimed that we had the right to use force against that group in self-defense, and we went after them in Afghanistan. So there's no question that what happened on October, in my mind, there's no question that what happened on October 7th, 2023, Hamas's incursion into Israel, was an armed attack against Israel. I mean, they killed, I think I have some data somewhere that shows this was the third worst, terrorist attack or attack by a non-state group against a state like since 1970. And especially when you think about how small a country is, I think if you do this on a pro rata basis, if we had sustained the number of casualties on 9/11, that on a proportionate basis that Israel had, there would have been like 30,000 people killed, like on 9/11, right? So it was a devastating attack that the Israelis suffered. So yes, I agree that the Israelis had a right of self-defense against a non-state armed group, against Hamas. Now, the question is, there's another principle. We talked about the jus ad bellum, the law governing recourse to force, and there's another principle associated with the use of force, is that your force has to be proportionate. So this goes back to old Christian just war theory. In the old days, the Christians were basically pacifists. But when, Augustine and Aquinas started writing about war, they said, yes, but there's some circumstances in which it might be appropriate for Christians to wage war. We can only do so if there's a good reason. But what they said is that the good of the war has to outweigh the harm that's going to be caused by the war, that's one of the requirements. And that is essentially the test that's built in to this concept of jus ad bellum proportionality, that the overall harm caused by a war should not be excessive in light of the state's legitimate war aims. Israel, I think, had a legitimate war aim of saying we're entitled to defend ourselves. But I think the way Israel chose to prosecute the war, the level of devastation, the extent to which attacks happened in urban areas, the displacement of so many people, attacks against sanitation systems, water infrastructure, health infrastructure. I think that the overall level of harm that Israel has inflicted in Gaza is excessive in comparison to its legitimate self-defense interests. Now, this is admittedly a hard test to apply because it's a little bit of apples and oranges. I have a self-defense interest, which is the good on the one hand, and I have the destruction of property and killing of civilians on the other. A little hard to balance these things. But, I've got a paper that's coming out on this that I've co-written with a co-author, Bailey Ulbricht, and we argue that even accepting that Israel had a legitimate right of self-defense, a right of protecting itself, it could have chosen military strategies, more counterterrorism strategies, more targeted killing strategies of Hamas leadership, right? That could, and also just improving its defensive posture. I mean, what we know is that Israel fell asleep at the switch, right, in terms of its intelligence apparatus that was designed to prevent this kind of attack from happening. So I think there are many other ways that Israel could have achieved its self-defense goals, its legitimate self-defense goals, without causing the level of destruction, the level of harm that it has in Gaza. So yeah, we argue that Israel has violated this principle of jus ad bellum, proportionality.
The other point I'd like to talk about that is, actually, I guess I should have mentioned it in Russia, Ukraine as well. How would I put this? What laws are governing what happens to civilians in war? I mean, both circumstances, the biggest casualty are to people like you and me, never to really the big leaders. They're usually somewhere else, but to the average person being potentially killed or losing some family member, where does the law start and stop there?
Yeah. So now we're kind of talking about the jus in bello.
Well,
Set aside whether we had a just cause for going to war, a legal basis for going to war or not. Now the war has begun, and we're governed by those rules governing the conduct of war. Jus in bello, international lawyers call it international humanitarian law. If you talk to guys in the U.S. military, they'll call it the law of armed conflict. And there's a quite elaborate set of rules that govern the conduct of warfare. Three basic principles I'll give you. I mean, again, it's many. I have a shelf here that I could show you that's full of long, long books on the law of armed conflict. But three basic principles. I tell my students, if you know these three basic principles, you'll understand really sort of the foundations of the law of war. First is the principle of distinction, which is to say, in wartime, there are combatants and there are civilians. And you can only direct military attacks against combatants. It is forbidden to target civilians or civilian objects. That's the first principle, the principle of distinction. Now, sometimes let's say the United States is engaged in a war. The Pentagon is undoubtedly a permissible military target. It sits in Pentagon City. It's surrounded by shopping malls. It's surrounded by, a dense urban environment. So an attack against the Pentagon would also cause civilian harm, even though that civilian harm is even though you're not aiming at civilians, you know that civilians are going to be injured. Second key principle here is the principle of proportionality. This is different from the jus ad bellum principle of proportionality, which is focusing on the overall harm. This is jus in bello proportionality. And what that principle says is that for every attack, the commander has to ensure that the unintended but foreseeable civilian harm is outweighed by the military advantage. It's only if the military advantage outweighs the anticipated civilian harm that you can carry out the attack. Again, apples and oranges. How do I balance military advantage on the one hand against civilian harm? It's tricky, right? This is always a challenge, but that's the basic concept. And then the third principle is the principle of precaution, which is that you're supposed to take all feasible measures to try to minimize harm to civilians. Now, I think there are really significant questions, right, about Israel's military operations and about Russia's military operations with respect to these principles. Russia has been targeting energy infrastructure, right? I think it claims that this is energy infrastructure, which is energy that is meant to support the Ukrainian military, but they're basically shutting out the lights for major population centers. It's quite clear that in fact they're either aiming at these energy infrastructure targets because they are civilian and they want to punish like Ukrainian civilians, or if there is some kind of military justification for it, these attacks fail the test of proportionality because the civilian harm that is being suffered outweighs the military advantage.
That would be going back to your example of how the Pentagon is near like a mall and how by approximate it's going to be.
Exactly.
Okay.
Exactly. Now the Pentagon, you might make a different calculation. Wow, that's where all the that's where the whole brain trust is. And if we could take that out, we might win the war. So again, what's the military advantage of attacking the Pentagon? Could be very significant. The military advantage of turning out the lights in Kyiv, right? Like, what is the military advantage? I think that's much more speculative. In fact, I'm not convinced that the Russians even think there's a military advantage, that they are aiming at these targets because, again, they want to make the Ukrainian population, civilian population, suffer in the hopes that this will, cause the Ukrainian population to turn against the government and sue for peace. I mean, look, the Russians aren't the first to do this. Before these principles of distinction, proportionality, and precaution were well established, rules of international law, that happened in the 60s, the 70s. Those rules were codified finally in the 1970s in the Geneva Conventions and the additional protocols, rather, to the Geneva Conventions, the 1977 additional protocols. But if you think about the conduct of World War II, I mean, the firebombing of Dresden, the name of the kind of strategic bombing that the Brits used this terms, the Americans didn't, but it was called terror bombing. The purpose of the bombing was to terrorize the civilian population in the hopes that it would cause them to overthrow their government, to bring about, to press for a surrender, right? The bombing of Hiroshima and Nagasaki, the bombing of Tokyo. Again, we were targeting civilian population centers, right? Now, again, by 1977, it's quite clear that this is prohibited. I think that's what the Russians are doing in Ukraine. I think if you look at some of the attacks that the Israelis have carried out, there are reports from Israel media saying there's a great story in a publication called 972 Magazine that talked about a couple of things. Number one, the Israelis were using artificial intelligence tools to help them identify targets, who was a fighter for Hamas. But more interesting and problematic for me was that if they figured out a guy was a Hamas fighter, they would drop a bomb on an apartment building and were willing to tolerate collateral or incidental civilian deaths of up to 15 to 20 civilians to kill a single, foot soldier. And in my mind, that is quite clearly incompatible with that test of proportionality. Yes, the guy's a good target. He's a fighter. But can you kill 15 civilians while aiming at one fighter? I think the answer is no. There are reports about attacks that Israel launched in densely populated refugee camps, right, using large munitions, dropping 2,000-pound bombs, to kill a single Hamas leader, knowing they had to know that dozens of people would be people who were civilians would be killed. So yeah, I think that we have seen in both theaters, both Russia, Ukraine, and Israel, Gaza, some very, very problematic failures to comply with the use in bello. I think in the Israeli case, there have also been significant issues about the blocking of humanitarian aid. Another obligation, apart from the three principles that we've discussed, Greg, that states have is to allow humanitarian aid to the civilian population. And the Israelis have, sometimes it's been tighter, sometimes, but there have been significant periods of time in which Israel has essentially blocked any foreign assistance, including food, from coming into Gaza. And it looks like a campaign of starvation, which is prohibited under international law.
Just, I guess, with two countries failing follow the law, do you see any repercussions for Russia or Israel? I mean, we've seen that they've kind of, for lack of a better term, kind of been doing whatever they want because I guess the assumption is that everyone follows this law because there's no police to police it, but we all understand there's a commonality of following it, and these two are prime examples of not following it. Do you think that the international community is going to maybe form a police to enforce these laws or take action against both these countries now to stop these examples from furthering at all?
Yeah. I don't think we're going to be seeing an international police force, anytime soon. And that's in part because powerful countries like the United States don't want it, right? We have historically been a country that has a good reputation for complying with international law, but it's not been perfect. We've violated the law
Plenty of times, I'm sure.
quite a few times, and we don't want the police coming after us, right? We want to preserve that discretion. Now, I will say, I mentioned that even though there's no court of general jurisdiction, there are international courts. I mean, as it happens, there's an international criminal court based in The Hague, right, which has the authority to exercise jurisdiction over crimes that are committed on the territory of those states that are parties to the Rome Statute of the International Criminal Court. Well, it happens that both Ukraine and Palestine have accepted the jurisdiction of the International Criminal Court. And the International Criminal Court has, in fact, conducted investigations and has issued indictments against senior leaders and military officials in Russia, including President Vladimir Putin. I mean, he's been indicted by the International Criminal Court for violating some of these rules that we talk about. Prime Minister Benjamin Netanyahu of Israel and the former defense minister of Israel, Gallant, have been indicted by the International Criminal Court. Now, that's a court, but still no police force. So does the International Criminal Court have, a group of commandos who can go to Israel and snatch Netanyahu? Can they fly into Moscow and grab Putin and bring him out? I mean, the answer is no. So again, this reflects the limits or the underdeveloped nature of international law. I mean, that said, it's not like this is nothing. Countries that are parties to the Rome Statute of the International Criminal Court have an obligation to arrest people who've been indicted by the court. Last year, or I guess in 2004, the G20 met in South Africa. Vladimir Putin didn't go because I think he was not confident that he would not be arrested by the South Africans if he traveled there. I think Netanyahu's travel schedule is going to be significantly affected. The U.S. is not a party to the Rome Statute. We don't have an obligation. So he's been here, but he hasn't been to Germany since October 7th, 2023. He hasn't been to other places in Europe. And what happens when he loses, when his time comes, when he loses power, right? When he's finally voted out, will the Israeli government hand him over to the International Criminal Court? This cannot be ruled out. You mentioned that I was the legal counselor in The Hague. There, I was, doing a lot of work with the international courts and tribunals, including the International Criminal Tribunal for the former Yugoslavia, the Yugoslavia War Crimes Tribunal. And one of the last things that I did was I was at the airport in the Netherlands that greeted the flight because it was a NATO flight. It was a U.S. aircraft, and I had been involved in kind of helping do some of the coordination. that brought Slobodan Milosevic, who was the former president of the Federal Republic of Yugoslavia, into custody in The Hague. When he was president and he was indicted, everybody said, well, he'll never be handed over. He's not going to surrender himself to the War Crimes Tribunal. But, nothing is forever. And I often tell my students when I think about these international criminal cases, there's no statute of limitations, right? This court will have jurisdiction 20 years from now over these individuals. And I'm reminded of an old adage sometimes when I think about these cases. I tell my students, the ox is slow, but the earth is patient. And so, this is not exactly the kind of accountability for violations of international law I think that we would hope for in a perfect world. But it's the best I think we can hope for in the imperfect world in which we live.
Lastly, more current, U.S. and Venezuela. I'm sure everyone by now knows that Maduro has been extracted with a black op and et cetera, et cetera. My more concern is Trump kind of justified this with he's the head of a drug cartel, and a drug cartel that they labeled as terrorists, so they have a justification to go in there. And also I've seen that there's been some sort of citement of Monroe Doctrine as well. Obviously there's a lot to unpack there, but if you were to unpack that, what's the best case argument U.S. can even make to justify what they did, if they can at all?
Well, I guess my view is that there really isn't one. I mean, the best case, look, as I said, states have the right to use force if they have sustained an armed attack or if they face an imminent threat of armed attack. Now, what the Trump administration has argued is that the flow of drugs coming from Venezuela is so harmful to the American public that it's like an armed attack. So that's kind of the best argument, is like functionally we're engaged in self-defense here. Now, my answer to that is twofold. Number one, it's quite clear that states are allowed under international law to do things that are unfriendly and even harmful to each other without triggering the right of self-defense. When the UN Charter was adopted, there were ways of thinking about, would there be things other than armed attacks that might justify the right of self-defense? And the idea was like, no, we just spent 2 centuries watching states use force to settle their grievances with one another. And we don't want to allow that to happen anymore. So we're really going to limit states' rights to use force in self-defense only in response to kinetic armed force operations. And the harmful introduction of drugs into the United States by Venezuelan drug gangs doesn't qualify. It just doesn't amount to an armed attack. It's not a use of force. The second problem is just a factual one. Again, the second problem is a factual one, which is when we cite the harm that the United States is suffering as a result of illegal drugs, the harm is caused by fentanyl, right? We're talking about deaths that are caused by fentanyl, and there's just really no evidence whatsoever that Venezuela is a source country for this fentanyl. I looked at the indictment of Nicolas Maduro, right, that the Justice Department had issued. The word fentanyl does not appear once in that indictment, right? It's like a 20-page, 30-page document, right? The word fentanyl is not there. Even the U.S. government isn't claiming in its legal documents that Maduro is a source of fentanyl. So I think the kinds of harmful drugs that are coming from Venezuela to the United States, the factual basis for treating this as the equivalent to an armed attack, I think even if there were a legal argument, and there is not in my mind, the factual foundations for that argument don't exist. So The U.S. has claimed that under U.S. law, we have the right to enforce our arrest warrants in a foreign country. That might be true as a matter of U.S. law, but it's quite clearly not true as a matter of international law. And again, it's just worth thinking, like, what if Venezuela, had indicted Donald Trump and, had sent in a commando team to arrest him? Now, could they have gotten away with it? No. Right? But would we have said, like, oh, well, I guess if it's legal under Venezuelan law, it's okay with us. You can invade our country and capture our leaders. Of course not. We would have been outraged. We would have been indignant. And that contrast between the way we react to what this would have happened if it had been done to us compared to the justification we're offering for doing it to another country suggests to me that this is not a policy which is grounded in law. It's a policy which is grounded in power. It's might makes right. If I can do this, then I can. And I don't need to have a legal justification. In his long interview with the New York Times correspondents, I haven't read everything, but it appears that President Trump has said, like, no, we're constrained by my sense of morality, my President Trump's sense of morality, not the law. So this is classically, an illustration of might makes right, which is the opposite of the rule of law, right? Which is that everybody is subject to the same rule, no matter how powerful.
You mentioned in the indictment that they didn't even cite fentanyl. Just out of curiosity, what was the core argument they were citing in their indictment? Was
The
it
focus is largely on cocaine
okay?
transshipment. Although even there, again, I'm not an expert on the subject, but from what I understand, from what I read in the paper, it sounds like most of there's a ton of cocaine that's coming to the United States. A lot of it originates in the Andes in either Peru or especially Colombia. And I think Venezuela it's not a production country, it's a transshipment point. But from what I understand, and again, I need to be a little tentative about this because this is not a subject of my own expertise, it's kind of what I read in the papers, but that most of the cocaine that comes through Venezuela ends up going to Europe. That the cocaine that comes to the United States ends up coming largely through Mexico, right? So now I don't want to give the Trump administration any ideas that we should next be invading Mexico, although, they've already talked about it. I mean, this is something that's already been, a subject of discussion. Would we use force, to attack, drug cartels in Mexico?
Just in closing overall, is there anything that you see that in the international law right now that is going to be shaping the next 5, 10 years of law, like the Russian-Ukraine deal, Israel-Palestine, the U.S. and Venezuela? Or is there something that the media is not even covering that it should be covering and we should be paying attention to?
Well, I would say this. International law is based, to a large extent on the behavior of states, what they do. But it's not only what states do, it's how other states react to it. So again, the Soviet Union annexed the Baltic states. The Soviet Union had the second largest arsenal of nuclear weapons. Nobody was going to use force, to liberate the Baltic states from Soviet domination, right? But the international community reacted in a way that said, we don't accept this. We don't tolerate this. So the first question will be, how will the international community respond? The record in response to Russia's invasion of Ukraine has been good. I think we see the extent to which President Trump has been effective at intimidating even a lot of our allies, who have been much more cautious in their condemnation of the U.S. invasion or the use of force incursion into Venezuela. The other thing is, because the conduct of states, at least in democracies, is ultimately driven by their leaders and who they elect. And so it'll be very interesting to see what happens in the coming years here in the United States and in other countries. Do we elect leaders? We'll have a chance to start seeing some evidence of this at the midterms next year, but certainly, in the presidential election that we'll be holding in 2028. Do the American people want to uphold these legal principles that kind of shaped the international order for 80 years, or do we want to move more to a system of might makes right, thinking that like, well, that works for us? I mean, my own view is, um, Americans want the United States to be an influential and a powerful country, but we're not bullies. Americans don't like bullies. And I think some of the way that we have seen this administration behave in terms of talking about running Venezuela, that if the current interim president in Venezuela, Delcy Rodriguez, doesn't cooperate with us, she'll get something worse than what happened to Maduro. To me, that sounds like a pretty clear threat of a targeted killing, of assassination. I think some Americans like this, but I think most Americans don't. We want America to be treated with respect. We want power. We want influence. But we also do believe in the rule of law. We do believe in fairness. We do believe in justice. And so it may be that the key question will be, how do electorates in Europe, in India, Hungary's election is going to be an interesting test case because you have kind of an authoritarian there. Turkey, will we continue to elect leaders who basically seem to embrace the might makes right model of international relations, or will we elect leaders who seem to believe more in the rules-based order, as the United States sometimes refers to it, as the rule of international law? So I think, these domestic elections around the world are going to be very, very important for helping us understand what the long-term impact of the events that we've been witnessing in the last 5-10 years in terms of increasing violence in the system.
Are there any more closing points you'd like to make before we end?
Yeah, just that, again, you want to emphasize that, these rules about not engaging in the use of force, nobody imposed these on the United States. These are rules that we embraced because we thought the international system would be better if states did not have the unfettered ability to engage in the aggressive use of force against their neighbors. Again, this is not something we're doing as a favor. This is not something that was imposed on us. It's not like that stop sign that I don't like on the street in my neighborhood. This was a rule that we thought the world in which states don't use force against one another is a better world. And I think we just need to be reminded of the fact that that is, when we think about the international system as a whole, maybe it's great for us to have Maduro out of power. But what violence, what harm are we doing to this larger system? And so I just encourage us to try to remember that we embraced these rules. We adopted them as an exercise of our sovereignty because we thought a world in which states could not use force against one another unilaterally was a better world than one in which they were free to use force whenever they wanted. And I hope we can be reminded of that and to recognize that this form of restraint is in America's interest.
Thank you for joining us, Professor. Greatly appreciate your time. And everyone, that was Rogue Thoughts.
Pleasure to be with you. Thanks for having me.